Welcome to Case Series. Don't forget to like, share, and subscribe for more courtroom drama.
We were here, we went through a few questions. You decided to exercise your right to self-representation. That's still your decision?
Yes, sir.
Okay, where are we at in your cases?
Going to trial.
Okay, we already have the matter set for trial, Madam Clerk.
Yep.
Yeah, we have you set for the on the February 24th trial docket. So what we'll do, we'll bring you back for a trial management on February the 6th at 9:30, and that will be the plea and discovery cutoff. Basically, you and Mr. Patterson will have your last not preliminary, but last plea negotiations. And if the case isn't resolved, we'll select your jury on the 24th, Mr. Davis. All right, take care. We'll see you then, sir.
Sir.
Mr. Way?
Good afternoon, Your Honor.
Good afternoon, Mr. Williams. This is Mr. Henry Davis.
Yes, sir. We have two case numbers, 24 CF 42 and 24 CF 59. Your Honor.
All right, tell me what's been going on with Mr. Davis's case.
Your Honor, I had plans to see Mr. Davis this weekend down in Franklin, and I had a little automobile problem, wasn't able to see him. I have Thursday, he's on my calendar for Thursday for me to visit him. And it's really to go over those medical records that he has expressed a concern about before. And and I've also initiated with some conversations with Mr. Patterson, and he has a few little details he has to take care of before we can really get involved in any possible negotiations. So if we could have one more pretrial conference. I understand we don't have a trial date, or you don't have a trial.
All right, buckle up, because today's court session has everything: lies, arrogance, and a shocking finale. First up, we've got a sovereign citizen who tries to outsmart the law by refusing to give his real name and pulling the classic family name versus legal name nonsense. If you've ever wondered how quickly that strategy crumbles under a judge's patience, you're about to find out. And if that wasn't enough, stay tuned, because later we're jumping into a Florida case that exposes the ugly reality of domestic violence, where a repeat offender finally faces his fate. It's courtroom chaos mixed with a dose of justice, and trust me, you're not going to want to miss the twists ahead. So grab your seat, because this isn't just legal drama. It's a crash course in how not to act in front of a judge.
Date until May, I believe. So if we could come back sometime before that, so we can let you know if we're going to be able to resolve it or continue and go to trial.
All right, let's go ahead and place Mr. Davis on the May trial day. He's been in custody for a very long time. That will be May 19th. But let's come back April 1st at 1:30 to see where we are after your meeting. And I believe you said on Thursday, 2 days from now?
That's correct, Your Honor.
All right, perfect. So I know you have a meeting on Thursday. We'll see you April 1st at 1:30.
Very well. And I assume Mr. Davis is still going to be in Franklin County Jail there. So that's where I'm planning on meeting.
I'm being told, yes, Mr. Davis will be in Franklin County.
I thought so. Okay, thank you, Your Honor. And that's the only matter I have before you, if I could be excused.
You may be excused. Thank you, Mr. Williams.
Thank you, sir.
Mr. Williams? How you doing, sir?
Got Henry Davis, Your Honor, two case numbers, 24 CF 42 and 24 CF 59.
All right, Mr. Davis, how you doing, sir?
Your Honor, we're presently set for trial on May the 19th. I've had a chance to meet with my client, the investigator has as well, and has some discussions with Mr. Patterson. So I still hold out hope that we come to a resolution.
Absolutely.
So, and I'm not sure about the status of the 5/19 date. I'm sure you're aware of that. So I think best we just leave it there right now.
Absolutely.
If something develops, we come up with a resolution. We know how to get on your docket.
Yes, sir.
Otherwise.
Let's come back May 8th
May the-
for trial management. And that way we can talk about if there's any last minute plea negotiations or plea offers, any motions in limine or anything we need to discuss. And of course, you can appear by Zoom, Mr. Williams. So that'd be May 8th at 9:30. And
Your Honor, I know Mr. Mr. Williams is aware of this, but just so everybody's on the same page, we will be proceeding on 2442 CF first.
That's the
Okay,
aggravated.
okay.
Good to clarify that, but that's what I figured. Yeah.
All right, thank you, Mr. Williams.
VO2. And here we go, the classic sovereign citizen declaration. I'll represent myself. Now, there's nothing wrong with self-representation in theory, but in practice, it often leads to disaster. Notice how he immediately complicates things by challenging even the most basic court procedure, like whether the list of rights is complete. This isn't legal genius. It's stalling, pure and simple. These tactics might seem clever in his head, but to a judge, it's just a waste of court time. And honestly, do you think this strategy ever works? Drop your thoughts below. Have you ever seen a sovereign citizen win with this playbook?
I'm not gonna ask what happened.
It was planned, so it wasn't an accident.
Okay.
Your Honor, today we're with State of Florida versus Henry Lee Davis III. Two case numbers, 24 CF 42 and 24 CF 59. Mr. Davis today is going to withdraw his previously entered not guilty plea and plea no contest to in case 24 CF 42 to count one, which is felony battery, a third-degree felony punishable by 5 years in Department of Corrections and or a $5,000 fine. He's also going to plead no contest to count two in that case to resisting officer without violence, which is a first-degree misdemeanor punishable by 1 year in the county jail and a $1,000 fine. In exchange, he's going to be adjudicated guilty. He will be sentenced to 50 months in the Department of Corrections. If there is any restitution, we're going to reserve on that. We'll set a hearing later. He will receive 434 days jail time credit. It'll be time served on that misdemeanor, which is count two of 24 CF 42. He'll provide a DNA sample, forfeit seized items, and the state has agreed to null pros 24 CF 59.
Yes, sir.
And I'll pass that up. And I believe
Mr. Davis, you'll raise your right hand for me, sir.
VO3. This is where things get interesting. Since we don't have body cam, the police report becomes the star of the show, and it paints a pretty clear picture. Switching lanes, expired registration, refusing to hand over ID, and then lying about his name? That's not some innocent mix-up. That's deliberate obstruction. He even claimed his ID was in the trunk, only for officers to find it in his pocket. It's a textbook example of someone digging their own hole deeper with every word. Question for you. If you're already caught driving with a suspended license, would lying about your name make things better or 10 times worse?
Did you hear Mr. Williams' announcement about how you're gonna resolve your cases?
Yes.
Anyone promise you anything other than what was stated here in open court?
No.
Threatening you, twisting your arm, coercing you in any way to get you to enter this plea?
No.
This is what you want to do to resolve your cases?
Yes, sir.
You know, the influence of any alcohol, drugs, or medication?
I'm on meds.
Yes, I believe your medication, I want to say helps you in your behavior and ability to think, but it doesn't affect you negatively in your ability to think, correct?
No, sir.
You understand what's going on today?
Yes, sir.
I know you do, you're highly intelligent, but there needs to be a record of it so I can find that your plea is voluntary and intelligent into. Mr. Davis, you're waiving your right to a trial by jury?
Yes, sir.
And you're waiving your right to appeal anything other than a legal sentence?
Yes, sir.
You satisfied Mr. Williams' services?
Yes,
Had
sir.
a sufficient amount of time to speak with him?
Yes, sir.
You need additional time to speak with him about anything?
No, sir.
I know you're a U.S. citizen, but I have to advise you if you are not, by entering this plea, it could subject you to deportation. You understand that?
Yes, sir.
You have any questions about anything,
No, sir.
Mr. Williams?
No, Your Honor.
I believe, I'm sorry, go
We
ahead.
would stipulate that there is no DNA evidence we're aware of that would tend to exonerate or exculpate my client, and we'll waive any formal reading of the costs associated.
Thank you. And Mr. Patterson, I believe you said there's a,
Yes, Your Honor, my office has been in contact with the victim. She is in agreement with this resolution, Your Honor. I do not know at this moment whether she wishes to address the court or be heard, but she is present if she wishes to do so.
all right, ma'am, would you like to be heard before I pronounce sentence?
Yes, sir, I would.
VO4. And there it is. The judge confirms probable cause. This is a critical moment. All of his stalling, all of his not in commerce arguments, none of it mattered. The court simply moves forward. But watch how he reacts. He refuses to accept the reality, trying to twist legal terms and argue that being found not guilty should just be automatic. This is the core flaw in sovereign citizen logic, confusing philosophical arguments with legal rulings. Courts don't operate on word magic. They operate on law and evidence.
I'll go ahead. First, could you tell me your name?
Katie Clark.
Ms. Clark, you'll raise your right hand to be sworn.
Yes, sir.
Swear from the testimony given this case be the truth, so help you God.
Yes, I do.
All right, Ms. Clark, what do you want me to hear, ma'am, before I pronounce sentence?
I believe Mr. Henry Davis does not need to get any time served. Me and my kids are still terrified of him. My kids still have nightmare because he threatened to kill my kids. I'm scared when he does this sentence, he's gonna get out and finish what he started. I'm scared, like I'm shaking now. I do not want him any time served at all. I'm petrified of this man. I still have nightmares from how this man treated me. And how he used to stomp and beat me for no reason. I don't know what you got your head down for. You had it up. Have it up now.
Ma'am, you have to just, Mr. Davis, don't
I'm
go there.
sorry.
Ma'am, it's fine. Just address your comments to the court, not Mr. Davis.
I'm sorry. I've been quiet for so long. I don't know what to do. Please just do not give him time, sir. Please, I'm scared of him. And I understand he's going away, but still, that time served is going to lower it.
Yes, ma'am. Anything else?
No, sir, that's it.
VO5. This is courtroom theater at its peak. He's hung up on the semantics of innocent versus not guilty, as if the choice of words could magically dismiss his charges. Judges see this every time sovereign citizens show up. They fixate on language games, but ignore the substance. The judge is patient but firm, making it clear. Not guilty isn't a finding. It's just a step in the process. What's fascinating is how these defendants truly believe that rejecting court procedure makes them immune. Spoiler alert, it doesn't.
All right, anything else, Mr. Williams?
No, Your Honor.
Mr. Patterson?
No, Your Honor.
Anything you want me to consider, Mr. Davis? Do we want to be heard on anything?
No, sir.
Okay. Well, I'm going to accept the plea. I'm going to find that it's known, intelligent, and voluntarily entered into. In case number 24 CF42, you'll be adjudicated guilty of felony battery, and that's priors, correct?
Yes, Your Honor.
Okay, I know that.
His charge is bodily harm.
Bodily harm, okay.
It's a level 6.
Perfect. All right, and resist an officer without violence, a misdemeanor, you'll be sentenced to 364 days on count 2. The resisting the officer without violence and given credit for 364 days on count 2. On count 1, the felony battery, you'll be sentenced to 50 months in the Florida Department of Corrections. You've been in jail for 434 days. You're entitled to that jail credit, and you'll be given credit for 434 days. You must provide a DNA sample, forfeit seized items, and there will be I'm going to add a no contact. There'll be no contact with the victim or the victim's family. You have any questions, Mr.
No,
Davis?
sir.
And the state agreed to dismiss or no pros case 24 CF59?
Yes, Your Honor, this time the state would announce a null prosecution.
Perfect. All right, Mr. Davis, best of luck to you. You've done at least in court, done a complete 180. Stay on the yes. And you have court costs and fines. Do I have that sheet? $1,357, and Mr. Williams has waived my reading discretionary costs and fines, and that would be reduced to a civil judgment.
Yes, sir.
Mr. Davis, best of luck to you. You got 30 days to appeal the judgment and sentence, and if you can't afford an attorney, we'll provide one for you. Yes, sir.
One other thing I forgot to mention, Your Honor, he would appreciate a recommendation from you to go to a DOC facility somewhere near Tallahassee, which is sort of centrally located for his family.
What's the app? Is the app? Guess for ladies. Is that Appalachia?
Appalachia is in Sneeds, yes, Your Honor.
Is there any other near Tallahassee?
I think there's one.
Jefferson.
Okay, and I'll recommend Appalachia or Jefferson CI or any facility near Tallahassee.
That's right.
Thank you, sir.
All right, thank you,
Your
Mr.
Honor.
Davis. Best of luck to you, sir. Thank you,
That's
Mr.
all we
Williams.
have. Thank you very much.
Thank you.
That concludes my business.
Absolutely. Thank you, sir, for your work.
I don't need to